So this is why the consultation requirement of getting the ambulance involved at the earliest point in respect of anybody who we might be thinking goes to police custody is really crucial, because if we get this wrong, it can, history has shown, lead to those incidents where somebody becomes rapidly very, very ill in police custody and is unfortunately dead or suffered a serious injury before we can then rapidly transfer them to an A&E department. So inspectors in particular need to make sure, firstly, did the officers call an ambulance? If not, why not? Try and get one there. Secondly, do the officers who made the detention have sufficient resources, either at the location of the detention or potentially at a place of safety or an A&E department, depending on where we're going to choose to go, in order to make sure that NHS staff remain safe, to make sure that NHS staff are supported as they try to get a quick clinical assessment about the needs of the individual. And of course, if it's been declared by the NHS that the clinical risks are not such as to mean that somebody needs to be in an A&E department, where behaviours are very challenging, very, very difficult to manage, it may be that the inspector has to give that authorisation in very rare circumstances to use police custody as a place of safety. So just to recap that one, place of safety options should be considered as following: get an ambulance to the scene, make a decision about where we're going to go. If the person's presenting with what you might call red flag medical emergency issues, clearly they need to be in an emergency department. If not, they need to be in a mental health unit place of safety. But unfortunately, the police station now cannot act as the kind of contingency backup plan, because there are now some very strict legal criteria about using police custody. So it may be that if an A&E department is not appropriate or unwilling to accept, if the mental health unit place of safety is either full or unwilling to accept, we have to think about this any other suitable place option and start thinking about whether somebody could be safely and appropriately removed to either to their own home or to that of friends or family. So that's the main part about how the big decisions at the start of the Mental Health Act amendments get made, but there are just one or two more things to say. The overall period of time that somebody can be detained in a mental health place of safety of any description has now reduced from 72 hours to 24 hours. The 24 hours can be extended up to 36, but this is in some very, very specific circumstances. The intention of the Act is that everybody is assessed and done and dusted, assessed by and interviewed by a doctor within the 24 hours. But if that assessment by the medics for mental health is delayed because of the condition of the person, then it is absolutely acceptable to extend the 24 hours up to 36. And the authorisation to extend must be given by the doctor who is going to be a part of the assessment, and it must be given prior to the 24-hour point being reached. Additionally, if the extension is going to occur in police custody, then the extension must also be authorised by an officer not below the rank of superintendent. So 24 hours to get everybody done and dusted can be extended up to 36 if there's a delay in the assessment because the person is ill or injured or intoxicated, but you cannot extend the 24 hours up to 36 purely because we're struggling to get an amp, a doctor or a bed. And that's very important to remember. It's not an administrative extension, it's an extension because of the clinical or physical condition of the person who's been detained. So those are the very main amendments. There are one or two others. You must remember the place of safety regulations relate only to adults, because it will be absolutely unlawful to use police custody as a place of safety for children. So if a 17-year-old is presenting in a way that the regulations describe of posing an imminent risk of serious injury or death, you still cannot use a police station in any circumstances. And please note that this is a ban on the use of police stations, not a ban on the use of police custody. So if officers, that as we know in the past have occasionally done, you can't sit that child down in the front office of a police station, or you can't use one of the witness or victim or witness rooms that we have for victims of serious crime, the slightly more comfortable interview rooms that we have. We can't improvise through those kind of options either, because typically those kind of facilities that are owned by the police are within buildings which are police stations, and it is a complete ban on police stations. Officers also, very finally, will now have powers of protective search under the Act. So if somebody's been detained under Section 136 of the Mental Health Act, it always has been the case that you can search somebody under Section 32 of PACE, assuming that the grounds are met within that section, so reasonable grounds to believe that the person has an item on them that can be used for causing harm or effecting an escape. That always has been the case, and that remains the case under the amendments. However, Section 136C, which is a new section to the Act, introduces protective searches after arrival at a place of safety. It's still effectively like a Section 32 search in that it still requires reasonable grounds to believe that a person has an item for causing harm or effecting escape, but this is a section that can be applied at arrival at the place of safety, and it can be considered for application at any time whilst the person remains detained. So on the one hand, whilst it's not a blanket power of search, it doesn't authorise a routine search of absolutely everybody. It is a power that can be applied at any stage that it becomes necessary to consider doing it. So if information comes in 5 hours into someone's detention in a place of safety that they are in possession of something to which a search power would relate, then the power can still be done even though it's a significant period of time after detention. Section 136C also contains similar powers of search for the execution of either a warrant under Section 135. So under Section 135 there are 2 different warrants can be issued by a magistrate's court for different purposes. Regardless of which warrant has been issued, Section 136C would still allow a Section 32 style search for any item that can be used for causing harm or effecting escape, and that search power can be used at any point from the execution of the warrant through to the point where Section 135 ceases to apply to that person because they've either been released or they've been admitted to hospital under the Mental Health Act. I don't pretend that that's every single one of the amendments, but those are the main amendments that are coming in for operational officers to consider. Please see your Force Mental Health lead who could be putting around guidance. The College of Policing have produced a guidance document on this topic. And also on my blog, mentalhealthcop.wordpress.com, there's a whole series of articles on there, a different article for each of the different amendments, where if you need to refresh your memory over anything I've just said or look into this in a little bit more detail, you certainly can do so. These amendments take effect on the 11th of December 2017. Anybody detained before midnight, so still on the 10th of December, should be dealt with under old law. So we will have a slightly odd 2 or 3 day period on the week beginning the 11th of December where some people may need to be detained under the old laws, and police stations may still be used for anyone who was detained on the 10th of December without reference to these new regulations. But by the time we get to the 13th of December, all detentions made after that period of time will be detentions that are subject to the new law, so it's important that we understand where the power can be used, who we should or may consult with prior to use of that power, where we can take people under the new circumstances, and how the whole process has to work from there, because the point here is to preserve the dignity and the safety of people we meet in distress, those of us who live with mental health problems, in order to make sure that they're safe whilst they're subject to these quite considerable powers of the state to ensure their welfare. Best of luck.